Imagine a company raising massive public confidence through annual reports, investor presentations, and corporate announcements, but secretly failing to hold its annual general meeting within the legally prescribed timeline. Shareholders are left without audited accountability, directors avoid uncomfortable questions, dividend approvals get delayed, compliance filings become vulnerable, and suddenly the company faces ROC scrutiny, penalties, prosecution exposure, and governance distrust. In corporate law, one missed annual general meeting is not merely a procedural lapse. It can become the starting point of shareholder disputes, regulatory action, and governance collapse. Section 96 of the Companies Act 2013 stands at the very heart of shareholder democracy, corporate accountability, and investor protection. Welcome to Corporate and Securities Law Compass, navigating law with clarity. Today, we are entering one of the most foundational yet most misunderstood provisions under the Companies Act 2013. Section 96, dealing with annual general meeting, commonly known across corporate practice as the AGM provision. Every company secretary, chartered accountant, director, compliance officer, investor, advocate, and governance professional must deeply understand this provision because almost the entire annual corporate compliance ecosystem revolves around the successful conduct of the AGM. When people casually hear the term AGM, many assume it is merely an annual formality where shareholders gather to approve accounts. But legally and practically, Section 96 represents something much larger. It is the statutory mechanism through which shareholders exercise control over management. It is the constitutional accountability platform of a company. It is the governance checkpoint where directors answer to owners. The legislative philosophy behind Section 96 is rooted in shareholder democracy. Under company law principles, shareholders may not participate in day-to-day management, but they retain ultimate ownership rights. The AGM is the bridge connecting ownership and management. Without AGM governance, directors could theoretically continue operating without meaningful accountability. Historically, corporate governance failures across jurisdictions demonstrated that management unchecked by shareholders creates serious risks. Investors require periodic disclosures, audited accounts, transparency regarding profits, liabilities, borrowings, related party transactions, and future business strategies. The AGM became the legally recognized platform to ensure this transparency. Under Section 96, every company other than a one-person company must in each year hold an annual general meeting. This immediately establishes a very important practical distinction. OPCs are exempt because the single shareholder structure eliminates the need for collective shareholder meetings. The provision further states that not more than 15 months shall elapse between two AGMs. This becomes one of the most important compliance calculations in secretarial practice. Professionals often incorrectly calculate AGM deadlines solely based on financial year closure. That is dangerous. Section 96 creates dual compliance conditions simultaneously. One condition relates to the time gap between two AGMs. Another condition relates to holding the AGM within 6 months from the closure of the financial year. For example, if a company held its previous AGM on 30th September and the next financial year closes on 31st March, the company must ensure compliance with both timelines. Failure in either may trigger non-compliance consequences. The first AGM enjoys special relaxation. A company may hold its first AGM within 9 months from the closure of its first financial year. Additionally, no AGM is required during the year of incorporation if this condition is satisfied. This provision becomes extremely relevant during incorporation planning and secretarial calendar management. Many startups and newly incorporated entities misunderstand first AGM timelines, particularly when incorporation occurs near financial year closure. Suppose a company is incorporated in January. The financial year may extend under applicable provisions. Professionals must strategically evaluate the first AGM due date in coordination with statutory audit completion, board approvals, and annual filing schedules. Another critical aspect under Section 96 concerns business hours and location. The AGM must be called during business hours between 9 a.m. and 6 p.m. and cannot be held on a national holiday. This requirement reflects legislative intent to ensure accessibility and participation of shareholders. The law recognizes that shareholder meetings should occur at reasonable times where attendance is practically possible. The meeting must generally be held either at the registered office of the company or at some other place within the city, town, or village where the registered office is situated. This geographical restriction protects shareholder convenience and prevents management from conducting meetings at remote or inaccessible places merely to discourage participation. However, for unlisted companies, there is an important flexibility. AGM may be held anywhere in India if consent is given in writing or electronically by all members entitled to vote. This provision becomes practically useful for closely held private companies, where shareholders may mutually agree upon a convenient venue. Listed companies must be particularly cautious because investor participation rights, institutional shareholder expectations, and SEBI governance principles make AGM compliance far more sensitive. Under SEBI LODR regulations, listed entities must also comply with additional governance requirements relating to notice disclosures, e-voting, stock exchange intimations, and publication obligations. The relationship between Section 96 and Section 101 becomes extremely important because AGM validity depends heavily upon proper notice compliance. A defective AGM notice may invalidate proceedings. Professionals frequently focus on the conduct of the AGM but overlook notice drafting defects, explanatory statement inadequacies, or dispatch irregularities. Notice must generally be given at least 21 clear days before the meeting. The phrase clear days itself creates examination traps and practical compliance mistakes. The date of sending notice and the date of the meeting are excluded while calculating clear days. Even courier delays or improper email records can create litigation risks regarding valid service of notice. Electronic delivery of notices has become an important compliance practice, particularly for listed companies and large shareholder bases. Companies must maintain robust proof of dispatch systems. The role of secretarial standards issued by the Institute of Company Secretaries of India becomes highly relevant here. Secretarial Standard 2 on general meetings provides extensive procedural guidance regarding AGM conduct. Though many professionals treat secretarial standards casually, courts and regulators increasingly view them as critical governance benchmarks. Board meeting procedures before AGM are equally important. Before shareholders can approve accounts, the board must first approve financial statements under Section 134. This means a properly convened board meeting must approve audited financial statements, board's report, corporate governance report where applicable, and AGM notice. The board resolution approving AGM notice becomes a foundational compliance record. Incorrectly drafted resolutions often create secretarial audit observations. The board must also authorize issuance of notice, appointment of scrutinizer where e-voting applies, and finalize cutoff dates for voting eligibility. Companies frequently commit mistakes by approving incomplete financial statements or unsigned audit reports before AGM circulation. Such procedural defects may attract governance concerns. Section 96 must also be read with Section 129 relating to financial statements, Section 134 relating to board's report, and Section 137 regarding filing of financial statements with ROC. The AGM is therefore not an isolated event. It acts as a central convergence point for multiple annual compliance obligations. During the AGM, ordinary business generally includes adoption of financial statements, declaration of dividend, appointment of directors retiring by rotation, and appointment or ratification related auditor matters as applicable. Special business requires explanatory statement under Section 102. Failure to provide material facts can expose the company and officers to legal challenges. An explanatory statement must disclose all material information necessary for shareholders to make informed decisions. Hidden interests of directors or promoters can create serious governance violations. Real-life governance failures often arise because companies intentionally provide vague explanatory statements to avoid shareholder scrutiny. For listed companies, institutional investors, proxy advisory firms, and activist shareholders closely analyze AGM notices. Weak governance disclosures may negatively impact market confidence. Another important concept linked with AGM governance is quorum under Section 103. Without valid quorum, the meeting cannot legally proceed. Professionals must carefully verify attendance records, authorize representative documentation, and proxy validity before commencement. Proxy provisions under Section 105 become practically significant, particularly in companies with dispersed shareholding. The chairman of the AGM plays an important governance role. Poorly handled meetings often escalate into shareholder disputes, allegations of suppression, and litigation. Voting methods have evolved significantly. Listed companies and prescribed classes of companies must provide e-voting facilities under Section 108 read with applicable rules. This transforms shareholder participation by allowing remote voting rights. Institutional governance standards now heavily depend upon transparent voting systems. Scrutinizer appointment becomes critical in e-voting and poll-based resolutions. Independent scrutiny strengthens credibility and reduces allegations of manipulation. Minute drafting after AGM is another highly sensitive area. Minutes are legal evidence of proceedings. Poorly drafted minutes can become litigation liabilities. Secretarial audit under Section 204 often examines AGM records, including notice, attendance registers, voting records, minutes, and statutory timelines. ROC filing obligations after AGM are equally important. Companies must file financial statements in Form AOC4 and annual return in Form MGT7 within prescribed timelines. Delay in AGM directly impacts annual filing timelines. Consequently, one missed AGM may trigger cascading compliance defaults across multiple statutory filings. Additional filing fees under Companies Act provisions can become substantial over time. Repeated defaults may also impact director disqualification analysis under Section 164. If a company fails to hold AGM within prescribed timelines, Section 97 becomes operational. Members may approach the tribunal for directions to convene AGM. This is a powerful shareholder protection mechanism. It ensures management cannot indefinitely avoid accountability. The tribunal may order calling of AGM and provide consequential directions including quorum-related relaxations. Failure to comply with AGM provisions may attract penalties upon company and every officer in default. But beyond statutory penalties, the larger damage is reputational. Investors interpret AGM delays as warning signs of financial stress, governance weakness, or internal disputes. Banks, financial institutions, and due diligence professionals frequently review AGM compliance history before lending or investment decisions. During mergers, acquisitions, and private equity transactions, annual compliance review always includes AGM verification. Due diligence teams examine whether AGMs were held properly, notices were validly issued, and annual filings match AGM approvals. One common professional mistake involves adjourned AGM confusion. Companies sometimes incorrectly assume adjourned meetings reset notice timelines or procedural requirements. Another common error occurs where financial statements are circulated without proper board approval before AGM dispatch. Private companies often assume AGM procedures are relaxed merely because shareholders are family members. This assumption becomes dangerous during future disputes among promoters. Family owned companies frequently enter litigation where one faction challenges AGM validity, alleging improper notice or manipulation of attendance records. Listed company AGMs increasingly attract ESG and governance scrutiny. Investors today question sustainability reporting, executive remuneration, related party transactions, and governance culture during AGMs. Virtual participation and video conferencing practices also evolved significantly, particularly after pandemic era regulatory relaxations. Professionals must carefully distinguish between temporary MCA relaxations and permanent statutory requirements. Dormant companies and small companies may enjoy certain compliance relaxations elsewhere under the Act, but AGM obligations continue unless specifically exempted. Foreign shareholders, FEMA considerations, and cross-border voting logistics also create practical complexities in multinational corporate structures. The company secretary plays one of the most critical roles in AGM governance. From drafting notice to coordinating e-voting, maintaining registers, preparing minutes, and ensuring filings, the CS acts as governance architect. Chartered accountants ensure audit completion, financial statement accuracy, and financial disclosure compliance. Advocates become crucial where shareholder disputes, oppression allegations, or procedural litigation risks emerge. Cost accountants may contribute particularly in regulated industries where cost records and audit disclosures intersect with shareholder reporting. An important hidden concept under AGM governance is shareholder psychology. Transparent AGMs build investor trust. Defensive or evasive management behavior destroys confidence. Corporate governance is not merely about legal compliance. It is about maintaining legitimacy before shareholders and stakeholders. From an examination perspective, students often confuse extraordinary general meeting with annual general meeting. AGM is mandatory yearly governance accountability. EGM addresses urgent or special business requirements arising outside ordinary annual business. Another examination trap concerns adjournment versus postponement. These concepts carry different legal implications. Professionals should also remember that accidental omission to give notice to a member may not always invalidate proceedings if statutory conditions are satisfied, but deliberate suppression can create serious legal exposure. Practical drafting precautions include ensuring consistency between board's report, financial statements, AGM notice, and explanatory statements. Mismatch between resolutions and filings is one of the most common ROC scrutiny triggers. Companies should maintain attendance registers, proof of electronic dispatch, voting records, and scrutinizer reports in organized compliance systems. Investor activism globally has transformed AGMs into powerful governance accountability forums. Questions regarding executive compensation, related party transactions, and governance ethics increasingly dominate shareholder discussions. Section 96, therefore, is not merely about conducting one annual meeting. It is about preserving the constitutional balance within corporate structures. Without AGM governance, shareholders lose visibility. Without shareholder visibility, management accountability weakens. Without accountability, governance failures multiply. Every director, promoter, company secretary, and compliance professional must therefore treat AGM compliance not as a routine ritual but as a core governance responsibility. In practical secretarial practice, the best companies prepare AGM calendars months in advance. Audit completion, board approvals, notice dispatch, e-voting setup, stock exchange compliance, and ROC filing timelines are synchronized carefully. This proactive governance culture minimizes litigation risk and strengthens investor confidence. Ultimately, Section 96 represents the heartbeat of annual corporate accountability under Indian company law. It protects shareholders, reinforces transparency, strengthens governance discipline, and creates a legally structured platform where management remains answerable to owners. A properly conducted AGM builds trust. A defective AGM creates litigation. A delayed AGM creates suspicion. A manipulated AGM destroys governance credibility. That is why Section 96 remains one of the most practically significant provisions for company secretaries, advocates, chartered accountants, directors, investors, and governance professionals across India's corporate ecosystem. If you like this video, kindly like, subscribe, and hit the bell icon for latest notifications from Corporate and Securities Law Compass. Like, share, comment, subscribe. Disclaimer: viewing this video or accessing the content on this channel are free and does not create any professional, advisory, or client relationship between the speaker and the viewer. The content is shared solely for general educational and informational purposes. The speaker is a member of the Institute of Company Secretaries of India, ICSI. However, the information provided in this video should not be construed as professional advice, consultancy, or opinion under any law or regulation. Viewers should not rely solely on the information provided in this video for making legal, financial, regulatory, or compliance decisions. Any person intending to rely upon or act on the information contained herein should independently verify the relevant provisions of law and, where appropriate, seek professional advice from a qualified professional. The speaker, the Institute of Company Secretaries of India, ICSI, and any organization or listed company with which the speaker may be associated shall not be liable for any direct or indirect loss, damage, or consequences arising from reliance on the information provided in this video or channel. The content shared on this channel is based solely on publicly available information, general legal provisions, and academic discussion of corporate and regulatory frameworks. The speaker confirms that no unpublished price-sensitive information, UPSI, confidential information, or proprietary information of any listed company or organization has been disclosed or discussed in any video or content on this channel. The views expressed in the videos are personal academic interpretations for educational purposes only and are not connected with or derived from any confidential information obtained through employment, professional engagement, or association with any listed company or organization. Nothing contained in this channel should be interpreted as market advice, investment advice, or insider information under the applicable provisions of securities laws, including the SEBI Prohibition of Insider Trading Regulations 2015. Viewers are advised that the information shared is purely for general educational awareness and should not be relied upon for investment decisions, trading decisions, or regulatory compliance without consulting appropriate professionals and official sources.